He pulled her over for a stop sign she never ran. He issued a citation for a violation that never happened. He threatened her on the side of a Kentucky road with his hand resting on his holster because she asked him a question he didn't like. And when she took him to court, he sued her back. That was the biggest mistake of Jonny Campbell's 8-year career, because the woman he pulled over that Tuesday afternoon wasn't just any driver. She wasn't someone who would get home, cry about it, and let it go. She wasn't someone who would take the ticket, pay the fine, and swallow the humiliation quietly like so many people before her had done. Helen Moore was a civil rights attorney, 19 years in, founding partner of Moore and Associates, a woman who had stood before the Sixth Circuit Court of Appeals twice and won. A woman who had spent 2 decades doing exactly one thing, making sure that people who abused institutional power faced the full weight of the law they claimed to represent. He didn't know any of that when he climbed out of his cruiser. He was about to find out, but before I continue, kindly hit that subscribe button so you won't miss the next story, and tell me in the comments where you are watching from. I love hearing from you all. It was a Tuesday afternoon in Harlan County, Kentucky. The sky was low and gray, the kind of overcast that makes everything look like it happened a long time ago. Helen was driving home after court, not as a defendant, not as a witness, as the attorney who had just finished winning a case for 3 families whose homes had been condemned without due process. She was already mentally drafting the next brief. Coffee untouched in the cup holder, hands at 10 and 2 on the wheel of her sensible grey Volvo. She wasn't speeding, she wasn't swerving, and she wasn't doing a single thing wrong. The lights hit her rearview mirror without warning. She pulled over immediately. No hesitation. No panic. She rolled her window down and waited the way anyone would, the way you're supposed to. And then Officer Jonny Campbell stepped out of his cruiser. He walked slowly, deliberately. The kind of slow that isn't urgency, it's performance. Broad shoulders, badge catching the grey afternoon light. 8 years on the Harlan County force. Our 8 years of people going quiet when he arrived. He walked up to Helen's window and looked at her the way some people look at an inconvenience. License and registration. No greeting, no explanation, just a command. Helen handed over her documents without a word. He glanced at the license, looked back at her, then glanced into the back seat. The kind of look that isn't curiosity. It's a search for something to use. You a lawyer? Yes. He smiled. Just barely. A small, certain smile. Figures. She said nothing. You ran a stop sign back on Cleaver Road. Helen blinked once. I didn't run a stop sign. Mom, I'm telling you what I saw. And I'm telling you what happened. Something shifted behind his eyes. Not anger, exactly. More like a decision being made. Step out of the vehicle. On what grounds? I'm asking you to step out of the vehicle. I heard you. I'm asking for the legal basis. He leaned in closer then. Close enough that his voice dropped into a register that wasn't quite a whisper, but wasn't professional either. You want to make this difficult? Because I can make it very difficult. A law enforcement officer, on a public road, threatening a cooperative, unarmed civilian attorney, because she asked him to justify his request. Helen didn't flinch. She didn't raise her voice. She didn't reach for anything dramatic. She simply picked up her phone, pressed record, and said, I clearly and evenly. Just so the record reflects, I have been fully cooperative. I have not raised my voice, and I am now documenting this interaction. Campbell straightened up. And for exactly 1/2 second, something crossed his face that wasn't quite shame, but was the shape of it. The first crack in a wall he had spent 8 years building, because 8 years of never facing consequences will make a man believe he never has to. He wrote her the citation anyway. Failure to obey a traffic control device. Signed it without looking at her, handed it through the window, got back in his cruiser, drove off. Helen took the ticket. She looked at it. She folded it precisely in half. She placed it inside her briefcase, next to her legal pad, between two case files. And then she drove to her office. Because Helen Moore had been handed something that afternoon that Jonny Campbell had no idea he'd given her. Not a citation, not an insult, not an inconvenience, a case, and she was already building it. Here's what he didn't understand. He hadn't just pulled over a lawyer, he had pulled over the one woman in Harlan County specifically trained to dismantle exactly what he thought the badge protected. He had handed her a ticket, looked her in the eye, and told her, without ever saying the words, that the rules didn't apply to him, that she was nothing, that she should take it and go. He had done that to people before. None of them had been Helen Moore. What was about to happen to Jonny Campbell would not just end his career. It would expose the system that had shielded him for 8 years. It would reopen cases he thought were buried. It would reach people he hadn't thought about in years, and it would all start, every single piece of it, with a traffic citation for a stop sign that never happened. He thought the badge made him invisible. He had no idea she could already see everything. There were people in Harlan County who remembered a different Jonny Campbell, the one who coached Little League on Saturday mornings, who helped his elderly neighbor drag a broken water heater out of her basement one February without being asked. Those people still existed. They'd just gone quiet, moved on, stopped bringing it up. Because somewhere between year 1 and year 8, that version of Jonny Campbell had been replaced by something else, something the badge had slowly built, and something unchecked authority had quietly assembled in the dark. It started with the first complaint. 4 years into his time on the Harlan County force, a driver filed a formal complaint against Campbell for excessive force during a DUI arrest. There had been witnesses. There had been a report. And there had been a union representative who sat beside Campbell in the internal review room and said 2 words that would define the next 4 years of his life. Insufficient evidence. The complaint was dismissed. Campbell walked out of that room and felt something he mistook for relief. It wasn't relief. It was permission. 2 years later, a civilian filed a second complaint. Threatening language. A noise complaint call that escalated far past what the situation required. Same union rep. Same review board. Same 2 words. Dismissed. Campbell walked out again. He didn't feel relieved that time. He didn't feel anything. Because by then it wasn't a surprise. It was a pattern he had come to rely on. The system would protect him. It always had. And the people around him, the supervisor who looked the other way, the colleagues who never asked questions, the review process designed more for paperwork than accountability, had all become part of the architecture that kept him standing. So he stopped logging body cam footage consistently. Not dramatically, just selectively. Just the times when it mattered that there be no record. He stopped expecting anyone to check his work. He started moving through stops with the certainty of a man who has never been told no and no longer anticipates hearing it. 8 years of that will change a person. Not loudly, not visibly, but completely. By the time Tuesday afternoon arrived, by the time he pulled in behind that grey Volvo on the road outside the Harlan County courthouse, Jonny Campbell was not a rogue officer in any dramatic sense. He wasn't unhinged. He wasn't out of control. He was something more dangerous than that. He was comfortable. Comfortable enough to climb out slowly and make a woman wait just to feel the weight of who was in charge. Comfortable enough to invent a stop sign violation on a road with a camera he didn't know about. Comfortable enough to say, "You want to make this difficult?" to a cooperative civilian, as if the threat were a tool, not a line. He had used that tool before. It worked. People backed down. They took the ticket. They paid the fine. They went home and complained to their spouses and let it sit in the pit of their stomach for a few days and then moved on. Because what were they supposed to do? And he drove back to the station that evening and filed the citation the same way he filed all of them. Quick, mechanical, done. He tossed his dashcam footage into the archive without reviewing it. He ate a sandwich at the break room table, laughed at something on his phone. By 8 o'clock that evening, Helen Moore was already a fading thought. He did not look up her name. And he did not Google Moore and Associates. He did not think about the Bar Association decal on her rear bumper or the small firm sticker beneath it. He did not ask himself, even once, who she was. That was the thing about 8 years of impunity. It doesn't just make you reckless. It makes you incurious. It makes you assume the person in front of you isn't a threat because no one ever has been. It makes you stop gathering information because you've never needed it. You've always been the most powerful person in the exchange, until you're not. Until the woman you handed a fabricated citation to goes directly to her office, not home, not a friend's house, but her office, and opens a blank case file and types your name at the top. Campbell had made a career of reading people wrong. He looked at Helen Moore and saw someone who would take the ticket and walk away. He saw a woman who talked back. He saw an inconvenience. What he didn't see was the 19 years of precision sitting behind her eyes. What he didn't see was coming. And by the time he realized it, the file with his name on it already had 3 exhibits. Helen Moore sat down at her desk at 4:47 p.m. She opened a blank document, and she started writing. Not with anger, with precision. Time of stop, 3:22 p.m. Location, Cleaver Road, southbound approach, 0.3 miles from the county courthouse. Officer identified as Campbell J., badge number visible, Harlan County PD Unit 14. First words spoken, license and registration. No greeting, no stated reason. Tone, dismissive. She wrote it all down, every exchange. Every word he used, and every word she used, back. The moment he said, figures. The moment he told her to step out without legal justification. The moment he leaned in and said she could make it difficult, or he could. The moment her phone went on. She wrote it all down in order, in exact sequence, the way she had been trained to document everything that might one day matter in front of a judge. Then she opened a second tab. Harlan County traffic camera grid. And Helen knew about those cameras because 6 months earlier she had personally reviewed the infrastructure grant application that funded their installation, on behalf of a client in a property dispute. She knew exactly which intersections were covered. Cleaver Road was one of them. The 4-way stop was another. She filed the public records request in 11 minutes. Then she called Marcus Webb. Marcus was a former federal prosecutor. In 15 years in the DOJ before he left to build a private practice focused entirely on police misconduct litigation. He and Helen had worked parallel cases twice before. He was the kind of lawyer who spoke quietly and moved fast, and had contacts in places most people didn't think to look. Helen described the stop the same way she'd written it, measured, clinical, precise. No embellishment, just facts. Marcus listened without interrupting. When she finished, he was quiet for a moment. Then he said, "Helen, do you know about the 2 prior complaints against this officer?" She didn't. But in the next 48 hours, she would know everything. 3 days after she filed the public records request, the county responded. Helen opened the attached file at her desk and pressed play. The footage was clear. Overcast afternoon light, slightly damp road. The grey Volvo approaching the 4-way stop on Cleaver Road. She watched the car come to a complete stop. Signal on. Full stop. Proceeding correctly. No violation, not even arguable. She made 4 copies immediately. 1 with her paralegal, 1 in off-site encrypted storage, 1 physically mailed to the Kentucky Bar Association Ethics Division with a cover letter she had spent 20 minutes making sure said exactly what it needed to say and nothing more. And 1 copy, printed, placed inside a manila folder, went to the top left corner of her desk. That corner was reserved for cases she intended to win. and she filed the civil rights complaint the same week. 2 causes of action to start: unlawful traffic stop and abuse of authority under color of law. Marcus Webb came on as co-counsel. They didn't call a press conference. They didn't leak anything. They just filed. Correctly, in the right court, with the right language at the right time. The Harlan County Police Department's attorney called the following Monday morning. Helen's paralegal took the message and brought it to her desk. They'd like to discuss a settlement. Helen read the note. She picked up a pen. She wrote 4 words on the bottom of it and handed it back. Tell him, in court. But here is what Helen had also discovered in those first 2 weeks, the detail that expanded a traffic stop complaint into something much larger. The 2 prior complaints against Campbell, 2 dismissed cases that, on paper, looked like due process. Reviewed, are considered, cleared. But when Marcus made a call to a contact inside the county records office, a different picture emerged. Both complaints had been reviewed by the same person, Campbell's direct supervisor, Lieutenant Ray Sutter, the man who had trained Campbell 9 years earlier, the man who carpooled with him 3 days a week, the man who had sat across from 2 civilians with legitimate grievances and signed off on dismissal both times. Helen filed a motion to reinstate both complaints as evidence in the civil suit. She filed a second motion flagging Sutter's involvement as a direct conflict of interest. 2 motions, filed quietly, no announcement, but the department felt them land, because this wasn't a traffic ticket anymore. This was a pattern. This was a system. And Helen Moore had just pulled back the first thread, with 3 more waiting underneath. The worst of it was still ahead. For 3 weeks before the court date, Jonny Campbell made a decision that would define the rest of his career. He filed back. Not through the department's legal counsel. They had quietly begun distancing themselves from him at that point, the way institutions do when they sense the ground shifting. Campbell had hired his own private attorney, a man named Gerald Pitts, who specialized in representing officers in civil disputes and who had, by his own count, gotten 7 similar cases dropped before they reached a courtroom. Pitts advised the counterfiling. His logic was simple. Make it expensive. Make it complicated. Put Helen Moore on the defensive. Force her to spend time and money defending herself rather than prosecuting him. It had worked before, in Fayette County, in Madison County, against people who were just tired enough to let it go. So Campbell signed the paperwork. The allegation: interference with a lawful officer. Obstruction. Filing a frivolous civil suit designed to intimidate and harass a law enforcement officer in the performance of his duties. He filed on a Thursday. By Friday morning it was in the local paper. By Saturday it was in the regional paper. By Monday a legal trade publication had picked it up under a headline that made Gerald Pitts go very quiet when he read it. Kentucky officer files obstruction claim against civil rights attorney he cited for stop sign he cannot prove she ran. Then the legal commentators found it. Then the former prosecutors started talking publicly, on podcasts, on legal forums, in op-eds. One retired federal judge wrote a piece about the pattern of officers counterfiling against civilians who challenge them in court. He called it a well-known intimidation tactic dressed in legal language. He named Campbell's filing as a textbook example. The Kentucky Bar Association opened a formal inquiry into whether the counterfiling itself constituted professional intimidation of a licensed attorney engaged in active litigation. That inquiry had teeth. That inquiry could result in referrals. Campbell had not anticipated any of this. He had seen people fold under counterfilings before, people who didn't have the resources to fight on 2 fronts, people who looked at the complexity and the cost and the exhaustion and chose to step back. He had counted on Helen Moore being one of those people. He had looked at her on the side of Cleaver Road and decided she was the kind of person who talked big and walked small. And he could not have been more wrong. Helen received notice of the counterfiling on a Thursday afternoon. She read through it once. Then she called Marcus. He read it. There was a brief silence on the line. Then Marcus said, "He just handed us a second case." Helen agreed. She didn't panic. She didn't hold a press conference. She didn't make a statement to the media who had now started calling her paralegal's desk twice a day. She sat down and she worked. Within 72 hours, and she had amended her original complaint to include a third cause of action: retaliatory legal intimidation by a law enforcement officer against a civilian exercising their constitutional right to seek judicial remedy. The counterfiling became an exhibit. Campbell's attempt to silence Helen Moore had just become evidence of the pattern she was already proving in court. Every time he had escalated, on Cleaver Road, in the complaint dismissals, and now in this filing, he had added another layer to the case against him. He couldn't see it. He was too close to it. He had spent 8 years in a system that rewarded escalation and never once shown him where it led. Now it led here. The department's attorney stopped returning Pitt's calls entirely. That happened on a Wednesday. By Thursday, Campbell had been quietly informed that the department would not be providing legal support for the counterfiling. He would carry it alone. And he was now standing in a courtroom on a case he had created against a woman who had been preparing for it her entire career. Without the department behind him, without the union stepping in, with a private attorney whose previous 7 victories had all been against people far less prepared than Helen Moore. The court date was 3 weeks away, and there was still one piece of evidence that no one, not Campbell, not his attorney, not even Helen herself, had fully examined yet. Something sitting in the dashcam archive, something 7 seconds long, something that, when it finally played in front of a jury, would change the meaning of everything that had come before it. Nobody knew it was there yet. But it was. The Harlan County Circuit Courtroom seated 80 people. Every seat was filled. Local attorneys had come to watch, not because they had been summoned, but because word had circulated the way it does in small legal communities, quietly and completely. 2 journalism students had driven 3 hours from Lexington. In the second row, a 67-year-old retired schoolteacher named Dottie Crane sat with her hands folded in her lap, wearing a navy blue blazer. Beside her was a 29-year-old man named Marcos Ruiz, who had driven in from 2 counties over. Neither of them had been invited. Neither of them had been asked to testify. They had simply come. Campbell entered with Gerald Pitts and sat at the defense table in his dress uniform. It was a calculated choice. Helen had expected it. The uniform as armor, the badge as authority, the same visual language he'd used on Cleaver Road, now deployed for a jury. She had told Marcus earlier that morning. "He'll wear the uniform. Let him." Helen entered in a dark charcoal suit. She set her briefcase on the plaintiff's table, opened it, and arranged 5 folders in a precise row. No theatrics, no pause for the room to look at her. Just the quiet efficiency of someone who had done this enough times that the room's attention didn't change anything. When called to present, she stood and addressed the court without a single note in front of her. She described the stop. Every detail, the exact words, the posture, the hand that drifted toward the holster when she reached for her phone, the tone of his voice when he said, "Figures." She gave it to the court the way she had written it that Tuesday evening, in precise, sequential, documented order. No emotion, no embellishment, just the facts landing one after the other with the weight of things that are absolutely true. Then she played her phone footage. The courtroom was quiet before. It went quieter. Then she played the traffic camera footage from the county's own infrastructure system. The grey Volvo on Cleaver Road, coming to a full and complete stop at the 4-way sign. Signal on. No movement until the intersection was clear. Proceeding correctly. The camera that Jonny Campbell had no idea existed when he wrote that citation. The jury didn't gasp. There was no dramatic moment. It was quieter than that. The specific silence of people watching something unambiguous, at something they cannot argue with, something that asks no interpretation. The stop sign sat there in the frame. The car stopped. That was all. Then came the cross-examination. Campbell took the stand with his jaw set and his back straight. His attorney had prepared him. "Stay calm. Answer directly. Don't volunteer information. Don't let her rattle you." Helen walked to the center of the floor and looked at him. "Officer Campbell, in your counterfiling, you described the plaintiff as engaging in obstruction. Can you define, specifically for this court, what act of obstruction occurred?" She refused to exit the vehicle immediately. "Did she eventually exit the vehicle?" "Yes." "Did she comply with all instructions after exiting?" A pause. "Yes." "Did she raise her voice at any point?" "No." "Did she make physical contact with you, your vehicle, or any object in a manner you could describe as threatening?" "No." "Did she, at any point during the stop, violate a specific law you can cite, with statute, before the citation was issued?" Long pause. Gerald Pitts leaned toward him. Campbell straightened. "I used my discretion as an officer." Helen let that sentence sit in the air for 4 full seconds. Then she said it. "Discretion without evidence isn't law enforcement, Officer Campbell. It's preference. And preference dressed in a badge is not authority." She paused. "It's a problem." Judge Patricia Colwell, 22 years on the bench, a woman who had heard every variety of courtroom performance imaginable, paused before asking the next procedural question. A pause of maybe 2 seconds. But in a courtroom that quiet, 2 seconds is a verdict before the verdict. Campbell looked at the table. But the most devastating moment of that day hadn't happened yet. Because during the evidentiary phase, Helen submitted one final piece of footage. The dashcam recording that the department itself had provided, confident 2 weeks prior that it would show nothing significant. And for 4 minutes and 11 seconds, it showed nothing significant. Then came the 4-minute 12-second mark. 7 seconds. And everything changed. Helen's paralegal had flagged it the night before the hearing. She'd been doing a final review of the dashcam footage, the recording the Harlan County PD had voluntarily submitted into evidence 2 weeks prior, because their legal team was confident it showed a routine stop with nothing unusual. They had reviewed it themselves. They had found nothing they considered damaging. They had submitted it without hesitation. They had not watched it carefully enough. At 4:12 in the recording, before Campbell ever reached the driver's window, before the first word was spoken, the dashcam caught him pausing at the rear of the grey Volvo. He stood there for 7 seconds, looking at the bumper. The camera caught the angle clearly. And what it captured him reading was this: a Kentucky Bar Association decal. And just below it, a small rectangular sticker that read, in clean, dark lettering, Moore and Associates, Civil Rights Law. He had known she was an attorney before he said a single word to her. He had read that sticker, and he had stood there, and then he had walked to her window and said, license and registration, without greeting, without explanation, with that small, certain smile, and called it a routine stop. Helen's paralegal sent her the timestamp at 11:47 p.m. the night before the hearing. Helen watched the clip 4 times. Then she called Marcus. "I see it," he said. "We play it last." She said, "Agreed." In the courtroom the following afternoon, after the testimony, after the phone footage, after the traffic camera, after the cross-examination, Helen submitted the dash cam for full sequential review. The jury watched it play from the beginning. 4 minutes of a traffic stop. Campbell approaching. The conversation. The citation. Nothing they hadn't already heard described. And then the timestamp rolled to 4:12. Helen said nothing. She let the footage play. The courtroom watched Campbell pause at the rear of the Volvo. They watched his eyes move. They watched him read. And 7 seconds of silence in a room of 80 people. Then he walked to the window. License and registration. Helen let it sit for a moment before she spoke. The record now reflects, she said, that Officer Campbell was aware of my client's profession before he initiated verbal contact. The court may draw its own conclusions about what motivated the escalation that followed. Gerald Pitts stood immediately. Objection. Speculation. Judge Colwell looked at him. Overruled. The footage speaks for itself. Pitts sat back down. That was the moment. Not the verdict. This was the moment. Because what those 7 seconds did wasn't just add evidence to a civil suit. They rewrote the story that Campbell had told about himself from the beginning. He hadn't pulled over a suspicious driver. He hadn't seen erratic behavior. He hadn't had reasonable cause. He had seen a law firm sticker, a civil rights law firm sticker, and he had decided, in those 7 seconds, to approach with the posture of someone looking for a problem. The question the jury now had to sit with wasn't just whether the stop was unlawful. It was why. And the why was sitting in 7 seconds of footage that the department had handed over themselves. Pitts asked for a recess. Judge Colwell denied it. Campbell sat at the defense table, and for the first time in the trial, for perhaps the first time in years, he looked like a man who understood what was happening. Not remorse. Not quite. More like the specific feeling of realizing the ground has been gone for a while, and you are only now looking down. The jury was sent to deliberate. In the hallway outside the courtroom, Dottie Crane stood near the window. Marcos Ruiz stood beside her. They didn't speak. They'd waited a long time for this. Dottie for 4 years, Marcos for 2. They hadn't known each other before this case. They'd been connected by a name on a complaint file. And now they stood together in a courthouse hallway in Harlan County, and they waited for the same thing. Helen came out of the courtroom and walked past them. She paused. She looked at Dottie, then at Marcos. She nodded. Once, nothing dramatic, just acknowledgement. Then she went to find a quiet corner and returned Marcus Webb's call. The jury had what it needed, and there was one more thing coming. Something beyond the verdict, beyond the damages, beyond Campbell's career, and something that would reach back through years and reopen doors that had been locked for a very long time. The worst for some people in this story hadn't happened yet. The jury deliberated for less than 4 hours. Complex civil rights cases routinely take days. 4 hours means the evidence didn't leave room for argument. 12 people watched that dashcam footage one more time, looked at each other, and didn't need long. When they returned to the courtroom, Jonny Campbell was already at the defense table with his jaw set in the same hard line it had held for 3 days of trial. Gerald Pitts sat beside him, shuffling papers in the specific way lawyers shuffle papers when they already know. Helen sat at the plaintiff's table, straight, still, hands folded. Judge Patricia Colwell read the verdict without preamble. In the matter of Moore versus Campbell, the jury finds in favor of the plaintiff on all 3 causes of action. Unlawful traffic stop, abuse of authority under color of law, retaliatory legal intimidation. Damages, $62,000. But the money was the smallest part of what happened next. Judge Colwell set down the verdict sheet and continued speaking in the precise, level tone of a judge who has made this kind of ruling before and understands exactly what it means. She ordered the decision forwarded to the Kentucky Law Enforcement Council for full disciplinary review, and she ordered both prior dismissed complaints, Dottie Crane's from 4 years ago and Marcos Ruiz's from 2 years ago, formally reopened in light of the established pattern. She issued a recommendation that Lieutenant Ray Sutter, Campbell's supervisor and the reviewing officer on both prior dismissals, be investigated for conflict of interest. Then she vacated the original citation. The stop sign violation that had never happened was officially and permanently removed from the record, erased, as if it had never been written, because it shouldn't have been. Campbell did not move. His attorney gathered documents with the careful efficiency of a man preparing to leave. 2 rows back, Dottie Crane closed her eyes for one long moment. Not relief exactly, something that takes longer to name. The feeling of being told by a court of law that what happened to you was real and wrong and that it mattered. Marcos Ruiz exhaled slowly beside her. Outside the courthouse, reporters were already gathering. Not a flood, not yet, but enough. Local outlets. 1 regional television crew. Campbell came out with his folder held up and his eyes down and walked to his car without a word. His badge was still on his uniform. But it looked different now. The shine had come off somewhere in the last 4 hours. Helen came out 2 minutes later and stopped on the courthouse steps. She checked her phone. There was a message from Marcus. 6th Circuit is already asking questions. This isn't over, in the best possible way. She typed back 2 words. Good. Keep going. She walked to her car alone. No statement, no press. She had a brief due in a different county by Friday, and her mind was already there. 2 weeks later, Jonny Campbell was placed on unpaid administrative leave pending the disciplinary review. The counterfiling was formally dismissed as retaliatory. The Bar Association inquiry had found sufficient grounds. Lieutenant Ray Sutter announced early retirement before the conflict of interest investigation could be completed. The Harlan County Police Department issued a new mandatory body camera review policy, the first policy change of its kind in the county's history. Implemented quietly. No press conference. No acknowledgement of what had made it necessary. That's how institutions move. Not in admission, but in adjustment. Dottie Crane received a formal written acknowledgement that her complaint had been valid. 4 years after she stood on the side of a county road in January, waiting while a man with a badge decided her questions were suspicious. 4 years. A piece of paper. It wasn't everything. It was something. Marcos Ruiz never got his phone back. That part didn't have a clean ending. But his complaint was reopened and referred. And that referral sat in a file that now had teeth. Helen Moore went back to her office on Monday morning. The Moore and Associates decal was still on her rear bumper. She had never considered removing it. Not before Cleaver Road. Not after. She opened the next case file and began to read. Because this was never about one cop on one Tuesday afternoon. It was about what happens when a system built on silence encounters someone who has spent their entire career learning exactly how to speak. Precisely. Correctly. On the record. Where it cannot be ignored and cannot be undone. Campbell thought the badge made him invisible. He forgot that invisibility only works when no one is paying attention. Helen Moore had been paying attention her entire career, and she wasn't finished yet. If this story hit different, if you felt that, share it with someone who needs to hear it. Because accountability doesn't happen on its own, it happens when enough people refuse to look away.